Good morning, Mike. Glad to be here. Well, with respect, I cannot agree with the reasoning of the Chief Justice of Ontario, and I have come to the conclusion that the appeal must be allowed. Well, yes, it is important to note that Section 4 of the Act deems that employment standards set out in the Act are minimum requirements only. According to the common law standard, the reasonableness of the notice must be decided with reference to each particular case. So having regard to the character of the employment, the length of service of the servant, the age of the servant, and the availability of similar employment, as well as having regard to the experience, training, and qualifications of the servant. Well, Mike, I just cannot accept this argument. If a term is null and void, then it is null and void for all purposes and cannot be used as evidence of the party's intention. In fact, it seems to me that the proper question to ask in determining the party's intention is, what did the parties intend should the notice provisions be found to be null and void? And there is simply no evidence with which to answer this question. And therefore, there is no way to warrant the conclusion that the parties would have agreed to substitute for the void contractual term the minimum period required by the Act. Well, Mike, not only is work fundamental to an individual's identity, but also the manner in which employment can be terminated is equally important. Therefore, I strongly believe in Section 10 of the Interpretation Act, which states that every act shall be remedial. If the only sanction which employers potentially face for failure to comply with the Act is in order that they comply with the minimum notice periods, then they obviously will have no incentive to make contracts with their employees that comply with the Act. Therefore, for all of the reasons I discussed this morning, I have to allow the appeal and accept the decision of the initial trial judge. No problem. Anytime, Mike.